everybody, Derek Ruiz here, and I'm super stoked to be interviewing Scott Schomer of the Schomer Law Group, who is a esteemed probate attorney, among other things. He is certified as a specialist in estate planning, trust, and probate law by the State Bar of California, graduate of Boston University, school law with over 25 years of experience. He has appeared on local and national television discussing the importance of estate planning. His firm, Schomer Law Group, is a professional law corporation that specializes in elder law, probate, wills, trust, and conservatorships. He has served as a member of the LA Superior Probate Volunteer Panel, Probate Settlement Panel, and a judge pro tempore. Scott's expertise has been recognized by his peers with such accolades as repeated nominations as a California super lawyer. Scott is also a fellow of the American Academy of Estate Planning Attorneys and an adjunct professor of law at Loyola Law School, where he teaches the next generation of attorneys about trusts and probates. About trusts and estates and probates, I'm sure. Very impressive, Scott. Welcome to our probate discussion. And before we start, I got a couple questions. What does pro tempore mean?
It's a temporary judge position. So I was invited by the court to sit, and I actually sat and heard cases and decided cases as you would a normal thing. But the appointment is a temporary appointment, as opposed to being permanently appointed by the governor or elected by the voters.
Got it. And what is an adjunct professor?
So an adjunct professor is, it's not my full-time job. So I come in and I teach one class at Loyola Law School, happens to be trusts and wills. So I am sort of like a consultant or a part-time faculty is maybe the best way to describe it.
Gotcha. Okay, great. And before we start getting in deep into probate, can we briefly cover what you do besides probate?
Well, I'd be happy to, Derek, and I appreciate you asking. So at the Schomer Law Group, we're all about preservation and protection of legacies and wealth. We want to build strong families and bring them together. Now, the way we do it is by looking at the way that you hold your wealth and looking at your assets, right? So with that, what we try to do is plan to make sure to try to keep you away from the probate court. I love the probate court. I go there on a regular basis. I don't like to bring clients there. It's always much better if you can do all of this privately, more efficiently, and with trusts and with private contracts such as powers of attorney, you can do some amazing things. So our practice includes the front end, what I call the front end, the planning, the preservation, wills, trust, powers of attorney. Our practice includes the administration of those estates when we lose somebody, so how you distribute and manage the assets. Our practice includes fixing those issues, dealing with those issues if you've not planned. Well, that's really where probate court comes in. And our practice also involves lawsuits and litigation, fighting when there's gray areas or when things aren't done correctly, or there's problems related to that. The vast majority of our trials are in the probate court. And then finally, a very important pillar of our practice as well is we are also wealth advisors. I'm a financial advisor. So part of what we do is we look at how you hold your wealth, and we'll, just like any good doctor, we'll give you our assessment on whether you are investing in a manner too risky or whether you're sufficiently diversified. So those are the things that we do. It's really all about protecting families, protecting legacies, and helping families grow generational wealth.
One of the things that's mentioned on your website is conservatorships. Can you give us a brief explanation of what that means and what you do?
Happy to do so. So the way that I like to cleave this area, if I can back this up just a little bit and give you sort of a broader umbrella approach, is there is a way to do most of what we deal with privately, and there's a way to do it through the public system. As I'm going to express to you in a minute, conservatorships are through the public system. So when you're dealing with a conservatorship you might think of as an adult guardianship. Why would you need a guardianship over an adult? Well, you would need a guardianship over an adult because that person's incapacitated, incompetent. Maybe they've had a stroke. Maybe they've had Alzheimer's disease or dementia. Or, probably the most famous one in the Southland recently has been the Britney Spears. There are allegations that she was not capable of managing her affairs. So when you get somebody that looks at the potential conservatee, like a Britney or like a senior, and says, we don't think they're capable of managing your affairs, what happens is a family member files a lawsuit. The lawsuit is called a conservatorship petition. And in it, one of the family members or a nominee go into court and say, we don't think the person here is capable of managing their affairs. We would like now to be their conservator. We'd like to be in charge of how they make their medical decisions. We'd like to be in charge of how they make their financial decisions. So you are literally taking over somebody's life. It's actually one of the most severe judicial remedies that are available, short of putting somebody in prison, which those in the Free Britney movement will tell you all about. But you're really going in and taking away somebody's rights. Now, can you do those things? In other words, can you plan for the potential that you may be incapacitated and avoid a conservatorship? Yes, you can. And that's a lot of what we do. One of the instruments we use for that is called a power of attorney, which I know you're familiar with. A healthcare directive, that's a document that gives somebody you've chosen the ability to make healthcare decisions about you. Both of those things don't require that you go into court. The other big tool that we use is a trust, because in a trust you will say, hey, Scott, I'm putting my assets in my trust, but if I'm not able to function and control them, I designate the next person to be the successor trustee and take over. So that's the private way of managing all this. Sometimes the private way fails, or sometimes the private way was never created. We all have freedom. That includes the freedom to do an estate plan or not do an estate plan. And when you don't put something in place to protect yourself, and there's no other option, if you're demented and you're incapacitated, then the last alternative is a conservatorship. That's what you end up filing.
So like quite a serious situation if somebody's got to go through conservatorship.
It is, because what happens is the court's got to screen. Well, first of all, the person whose rights are being taken away gets a voice. They may stand up and say, I don't want this, and they may fight it. And there may be an issue of whether they have the right, they have enough capacity to do that. The second thing is you've got to screen the person who's being appointed. Are they qualified? Are they a good credit risk? Are they going to be honest and fair? Can they post a bond? The third thing is that their activity, the conservator's activity, is going to be monitored and supervised by the court. So what that means is if I go in and take over as somebody's conservator, I have to do accountings every year explaining how I spent the money, where the money went, any professional fees I have to get approved in advance, any extraordinary action like selling a house, for instance. You have to go into court and say, hey, the person who's under conservatorship has a house. We'd like to sell it. May we do so? And everybody in the family, everybody that's related to the conservatee gets notice and has a right to weigh in and say, no, we don't want the family house sold. We object. We think this is not a good thing to do. So it ends up being administration of somebody's life under a court proceeding with everybody in the family getting a vote. What that translates into is slow, expensive, cumbersome, and not what I would call a ton of fun.
Yeah, I work as a probate and trust real estate broker. I work with a lot of people in the home care, healthcare for seniors business, placement agents and stuff like that. And I occasionally get phone calls. And Derek, I got a call from a daughter. Her mom's going to be needing care, and there's a trust and whatever. And I go, have she been evaluated by a doctor? No, not yet. And then I said, you're going to have to get an evaluation from a doctor to find out if this person is competent enough to make these kind of decisions to sell the house to pay for the care, because that's what usually it comes down to. Mom's got a house paid off, it's worth whatever 700, 800, a million, and they need that money to pay for the care, the assisted living care. And I've had so many situations where they weren't competent, and then they were going to have to get a conservatorship, and it's like, oh my God, that's going to take months, year, I don't know, whatever. So, it's a kind of a tough situation to be in. I've been in that situation as a realtor several times.
Well, one of the most heartbreaking situations that we encounter on a reasonably regular basis is where you have one of the spouses who is incompetent, but the other one's not. Right? So when you go to sell a house, if a couple owns it, they both need to sign off on the sale of the house. Well, if one's in a facility and not competent to do it and you don't have any plan in place, what you end up is the husband literally has to sue the wife to put her under a court monitored conservatorship, then has to go ask permission from the court to get the place sold, has to get the place appraised before they do it. It's just really, really painful and hurtful. And from my perspective, all of this stuff could have been dealt with very painlessly if that couple had come to see me 2 or 3 years before she became incompetent. If they had sat down and we had done a good trust, we had talked through all the possible contingencies. Hey, would you want to sell the house? Would you not want to sell the house? These are the deep and very meaningful conversations that we get into with families about, I know this is painful to think about, but let's play a game where we envision the road ahead. And how would you like things to turn out? Who would you like to be in charge? How would you like things to proceed? And the good news is I've been down this road, both the good and the bad, so many times that I consider myself to be a really, really excellent guide at helping people find the right solution for them.
You mean you got a good bedside manner?
Well, I try to do that too as well. Right? That's it. I mean, these are you're talking about selling your family home.
Yeah.
These are painful conversations.
Now, I went through a situation this year. I worked with a gentleman who I guess was in stages of dementia, and his successor trustee was his girlfriend. They were living together, and she wasn't the beneficiary, but he had family members that were beneficiaries. But what the attorney did was, I guess, petition the court to allow the successor trustee to sell the property, even though the trustee was not mentally capable, and the court said, okay, we're going to grant you the ability to act as a successor trustee and sell the property. I didn't even know that was possible till this year. So that's a important fact to know if you're ever in that situation. Does that make sense?
Oh, it makes perfect sense. And these are things that we're called on to do. I was just in my law class this morning. I was at Loyola, and I was teaching the subject of trustees and fiduciary duties. And one of the things that, one of the areas that I point to is go back and look at the Boy Scout law. Remember the Boy Scout law, Derek?
Be prepared.
Clean, thrifty, reverent, honest, all those things. That's what a trustee is called to do. So let me put you in the shoes of the girlfriend. I don't know your case at all, but let me just hypothetically talk about it. So if you're looking at having to sell a house, you're going to probably incur tax consequences. The boyfriend is going to owe a giant tax bill because he's probably owned the house for decades and not have a bunch of a break. If the house is held until his death, the beneficiaries can get all that revenue without any tax ramifications at all. So it's kind of a situation where the girlfriend is sitting there saying, I might be damned if I do or damned if I don't. Which way do I go? Is it a smart thing to sell it? Is it not a smart thing to sell it? Which decision should I make? And so one of the great things about the court system with trustees is if you find yourself in an impossible pickle, you can go into the court system and you just lay the facts out. Your Honor, I'm the trustee trying to do the right thing. Here are the pros, here are the cons. Here's what I recommend, but I'm putting it in front of the judge because this decision is over my pay grade. I want you, the judge, to make the final decision. In your case, it sounds like the judge looked at what she was proposing, agreed with her that selling the house was in the best interest of the settler, her boyfriend, authorized you to sell the house. You did it, and now she has protected herself from having the kids come back later and say, hey, you acted badly as a trustee. You should have waited for the market to go up. You should have waited until he died. So I almost think of it as a great partnership with the courts. And one of the things that's unique about our practice, because we not only do the planning, but we do the administration, and we're in court on a regular basis, and we understand investing and finance. So we have sort of the complete package and the complete picture. We can really get you in the right direction and figure out the best way to handle any situation like this.
Awesome. All right, let's pivot more into probate, because that's really the focus of this video today for the viewers. Is I really wanted to get deep into hardcore probate stuff when it comes to real estate. So give me a paragraph just to explain to the audience what exactly is probate.
That's a great thing. I'll come at it at a couple of different angles. So the place I like to start is that probate is a lawsuit you file against yourself. How's that for a definition? You like that one?
Never heard that.
It's a lawsuit you file against yourself. So what in the world am I talking about? Let me back up and let me put some concrete example on it. Okay, so Derek, let's say that I own a house. It's in my name. And you come to me and you say, Scott, I like your house. I want to buy it for $1 million. And I say, great, Derek. Let's consummate the deal. So we sign a purchase and sale agreement. How do we get that done? Well, at the end of the day, what happens is you hand me a check for $1 million. We do it through escrow and title, right? Mm-hmm. And I hand you a deed. So we prepare a deed that says house transfer from Scott to Derek, and I sign it. I sign the deed and I deliver it to you. It would be through escrow, but to you through escrow. The act of me signing and delivering transfers ownership of the property to you, right? Mm-hmm. You got it? Very simple. Now let's do the same hypothetical. Let's say we sign this deal, and then the day before, well, let's make it dramatic. I'm driving down to the escrow office to sign the deed, and I get hit by the bus and I die. Now how do we finish the sale? Right? How do I sign my deed? I can't. I'm dead. Right? So if you don't have any other devices, if you don't have any other way to do that, this is exactly what probate is for. So my kid or my wife would file probate. They would file a lawsuit, and they would go into court and say, Scott's got some business to finish. He's got a house to sell to Derek, and he can't sign the deed. So my wife would go into court. She would ask to be appointed. There's a whole thing about who gets to be appointed, but just for ease, we'll say my wife gets appointed. The court would then appoint her to be the personal representative, a position you would know as either the executor or executrix or the administrator. Okay? So that's the person who gets appointed to be in charge of my estate. When you get appointed and the court issues these things called letters, you've heard of letters before, letters of administration, letters testamentary. I like to describe those as keys to the car, but what they do is they vest Scott's legal authority in my wife. Okay? So that question about how do I sign the deed when I'm dead? The court has now blessed and given my wife the authority to sign for Scott, right? So Colleen, my wife, can sit down and sign the deed, and boom, you and I can finish the transaction that we had started, but I couldn't finish because we didn't complete it. Okay.
So basically, if somebody passes away and their assets are not in a trust, they are going to have to go through the probate court system, whether or not they have a will. Correct?
Yes. So I would say it just a little bit different. You're really on the right track, but I'd say it a little bit different, right? So a person who passes away, they have to file probate for that person if their assets are not in probate avoidance devices. So you identify a trust. A trust is one probate avoidance device. Another probate avoidance advice would be joint tenancy, because the full name of joint tenancy is joint tenancy with the right of survivorship. So that passes outside of probate. Or beneficiary accounts. Your IRA says when I die, pay it to. That generally avoids probate. But if you have assets that are in your name alone that can only be transferred, then that's when you need to file the probate. Now, you asked about the will. The purpose of a will is a set of instructions to the probate judge to be used in your probate when you're dead. That's its sole purpose. It doesn't deal with your pay on death. It doesn't deal with your joint tenancy assets. It usually doesn't deal with the stuff in your trust. All it does is give instructions to the judge on this probate lawsuit that may have to be filed. And so a will would say, hey, I, Scott, put Colleen, my wife, in charge. I give it all to her, and if she's not alive, I give it to Mike. Something like that, right? But you don't have to have a will to have a probate. Because remember, the probate is essentially the last method of transferring assets. It's the method of last resort. So if you've done nothing, we all have freedom in this country. Freedom includes the freedom to make a choice to do nothing. Freedom includes the right to make bad decisions. So if you decide to own a bunch of real estate in your name and never create a trust and never create a will and do anything else, that's okay. The probate court will take you. Come on in, and they'll help your heirs process your real estate and get them to the next generation.
Okay, so what exactly is the probate attorney's role? What is your role in a probate case? Somebody passes, they got to go to probate. They don't know what to do. What is your role in the process?
So I consider myself to be the expert guide through the system. So the filing of a probate, the process of probate. So we talked about the filing of it. The whole process, soup to nuts, takes a minimum of about 9 months. More realistically, about a year to a year and a half in LA County, because we are so busy here in LA County, right?
A lot of people dying.
A lot of people die. We have, if you don't know this, we are the litigation capital of the world.
Oh yeah, I know.
More lawsuits filed in Los Angeles County than any other single jurisdiction in the world.
I believe it.
And we have, and I think we now have 11 dedicated probate judges downtown. It's remarkable. But even the most basic things. How do you file a probate petition? What do you say to the judge when you go to the first hearing? What's this thing about probate notes? What do you mean I have to hire a probate referee? What do you mean I have to get my property appraised? What's an accounting? What's a notice to creditors? What's a notice of proposed action? There's all these little technical steps that come along the way on the process of a probate administration. So the role of an attorney, what we are doing is that we are looking for or need to find a fiduciary. So if I've written a will and I say my wife, that's our fiduciary.
What is a fiduciary?
A fiduciary would be the person that would take over the legal administration of the estate. So a fiduciary would be an executor, a fiduciary would be an administrator, fiduciary could also be a trustee, could also be an agent under a power of attorney. So I'm looking for that person that wants to process the dead person's assets, right? And then my job is to get them step by step through the process. But more importantly, my job is to make sure they don't do anything that gets themselves into trouble. They don't do anything that exposes them to liability. So if we go back to your scenario about the girlfriend wanting to sell her boyfriend's house in the trust, that's a scenario where she could have gotten sued by the beneficiaries. She could have gotten herself into trouble. She could have not sold the property and be sued for abusing him and just staying in the house. She could have been sued for selling it and having to have all his tax liability. So my job is to sit with the trustees, to sit with the executor, to sit with the fiduciary and say, let me understand what your goals are. Your goals are to get the money, to get the assets to the next generation, pursuant to the way that the dead person wanted them. Let me help you do that step by step and get it over the finish line for you.
Well, plus, you're obviously representing them in court when there's hearings and stuff.
Yes, we go to court. We fill out the technical paperwork. We supervise and prepare the accountings. We will quarterback the income tax filings, the 706, which are the estate tax filings. We will consult on dealing with taxation issues. One of the things that a lot of people don't have any idea about is actually one of the best benefits everybody gets is when you die, you get something called the step up in basis. Now, Derek, you probably know this because of all your work in real estate, but essentially what that rule says is that if you die holding a capital asset, and real estate's a capital asset, that the basis steps up to the fair market value at the date of death, which means your heirs can sell it without any capital gains tax immediately. But I've seen administrators, trustees, various people go off and sell the assets and file tax returns. And you look at the tax returns and you go like, why did you write a check to $100,000 for the IRS? And they go, oh, well, we had capital gains on the real estate. No, you didn't.
But their accountant didn't know that?
I've seen EAs and CPAs that did not understand that basic principle. And I've seen financial advisors that don't understand that basic principle.
You're kidding me. That's like basic accounting 101.
It's basic. I'm telling you, I have seen major money houses, names of which you would know, that were managing the money and reported to the client, to the trustee afterwards. Here's all your tax liability for the stock sales, and nobody sat down and readjusted the basis or thought about it or calculated it. So, what do I do? What do I do as the attorney? My role is really, I'm the trusted advisor, right? So I'm going to quarterback this whole thing. Your goal is you want to protect, preserve, and then pass your wealth in whatever form on to the next generation. I'm going to make sure that we get you in the hands of the best real estate people like you, Derek, to get out there and market and sell the property. I'm going to make sure the client understands what the step up in basis is, that they understand what the tax consequences are. I'm going to make sure that they understand what the requirements are as a trustee or a fiduciary. I'm going to get the work done, and I'm going to bundle it up in a package, all delivered, and wish them well, and send them on their way. So
yeah, I know. I can't believe that some PRs chose to choose to handle a probate case without an attorney. Is it called pro se? I can't remember what the
pro se or pro per. Yes, it's painful to watch. I've had trials against these people, and there's nothing like somebody showing up in court and thinking that they learned everything they needed to know on law and order, and they understand the rules of evidence. And
hey,
it's
for my audience that's listening, if you ever have to go to probate, call Scott. Don't try to do it yourself and save a few bucks. It ain't worth it, believe me. Another question I have for you: how is a PR chosen? An executor or administrator? How was that PR chosen?
So when you're talking about a personal representative, you're talking about probate.
Yeah.
Right?
Yeah.
So you can also have a fiduciary who's a trustee, but your starting principle is always to look at the testator's wishes. So is there a will, and who is listed in the will? So the first person that is listed in the will is going to be the first choice, unless there's an obvious problem, like they can't post a bond sometimes, or maybe they're in jail and they can't do it, or they're dead. But you'll go down that list. From there, in the probate code, there is a list of priority. So you'll go through and you'll see basically it's parents, children, close relatives. There's a whole list of order. One of the things that we have probably the hardest battles with is where you get a pair of kids that are fighting to be in charge of mom or dad's estate. Because under the code section, if they're both kids, they both have equal priority and equal standing. And at that point, you basically are leaving it up to the judge to make a decision as who do they think is the best person. And more often than not, what the judge will say is a pox on both of your houses, and I'm gonna use my discretion and appoint somebody independent because you kids are fighting.
Can there be like co-PRs, like co-trustees?
So not preferred, but if they're named, or if two people have equal priority and want to serve together, the court will allow it.
Okay.
What
I thought I
yeah.
was under the impression that almost anybody could file a petition because
Well,
I've been involved in cases, in sales, probate sales, where you know somebody's cousin in Milwaukee filed a petition, and it's there was competing petitions. I guess that could happen, right?
yeah, anybody that has some connection to the estate can. There's again, what you're looking for is either being named in a document or you're looking for some type of biological relationship.
Okay,
So, yeah.
got it. And what do you think are the most common mistakes people make during the probate process, other than not hiring an attorney?
Yeah. Um, the most common mistake is that people don't respect um, the fact that they are that the money or the assets that are under their control are not theirs. It sounds like a weird thing to say, but I've seen a number of estates where somebody will sell a house and then they just start passing the money out, or they just start giving gifts to people, or they get control of a bank account and then they just start pulling cash out. And you look at them and go, "What's this for?" "Oh, well, it's an advance on my inheritance." No, you don't. It's not your money until the court says it's your money. In a probate, it's not your money until the end of the case, right? And if you're managing it as a PR, if you're in charge of those funds, you're under a fiduciary duty.
Right.
But some people just don't get it. And in fact, one of the important things is, in the absence of any other scenario, what every personal representative has to do is eventually is prepare a full accounting, and the accounting addresses every single penny. We literally build them from bank accounts, right? So we grab all the bank accounts and we go through and say, "Oh, look, here's a 30-cent charge. We have to include that on the accounting." So the idea that, oops, they won't miss 10,000. I just took a little trip. Nobody will notice.
Huh.
Or I'm just going to pay. I mean, you laugh, but we see it on a regular basis. It's really,
Listen, man, I've been involved in so many probate and trust sales and a couple conservatorship sales, and people, this,
yeah,
people just come out of the woodwork.
yes, yes,
Oh, Auntie Mary Lou, she passed away, and I was her favorite niece, and how much am I getting? It's crazy, and I've seen fights, and I got a trust sale going on right now where the administrator and there's like 6 beneficiaries, and nobody can agree on anything, and it's just been dragging on. So that's it. Another question: how do probate attorneys get paid on a probate case? It's not hourly, it's not a chunk sum, but I think there's some kind of statutory. Can you explain how a probate attorney gets paid?
yeah. The way I like to break it down is there's essentially 3 forms of expenses related to the lawsuit during the course of this thing. So the first category is sort of the easiest one. It's third-party costs, right? So when I take a petition down to file it, the Superior Court looks at me and says, "Nice to see you, Mr. Schomer. $465, please." That's a cost. Somebody has to pay that. That has to come out of the estate, right?
A court fee or something?
That's a court fee, right? And you got to pay one to file it. You got to pay one to close it. You got to pay at various points along the way. You hire the probate referee. You got to pay him or her. So those are third-party costs, right? On average, on a normal, run-of-the-mill probate with a house and some other bank accounts, you're probably looking at about $2,000 to $3,000 in cost between court costs, publication costs, other things like that. Okay. So that's the first level of cost. The second level are the 2 categories of fees. So the first category fees are what are called statutory fees or statutory commissions, and they are set by the statute. If you're a geek and want to look it up, it's in Probate Code 10800. This is actually for the administrator's fee, 10800. And what it does is it runs on a percentage of the value of the estate. So it's not as simple as a real estate commission. It's a sliding percentage based on the value. So it's 4% of the first 100,000. It's 3% of the next 100,000. It's 2% up to $1 million, and then it's 1% over a million up to 10 million, and then it's at the discretion of the court afterwards. So what you need to do is just add up the value of the estate and do the calculation, and then you come up with a precise number. The easiest way to think about it is if you have an estate that's worth about $1 million, the statutory fee will be about $23,500, about $25,000. Now, that statutory fee or that statutory commission is payable to the attorney representing the administrator, but an identical fee is also payable to the administrator.
Oh, so the PR gets paid for all their hassle too.
Oh yeah, being an executor is a job. It's work.
Oh, I know.
You've seen it.
I remember talking to executors and administrators, and they're just like complaining and like, "Oh my God, this is such a hassle. We got to clean the house. They got to go to court. Blah blah blah." So yeah, I mean, at least they get compensated. So there's no real negotiating. I mean, you're not, PRs aren't negotiating with attorneys on fees. It's just set by the California state statutory laws.
Correct, but there's one other exception to that. Now, there's a number of probate estates where the work that is required is above and beyond the pale, right? So, for instance, if there is a lawsuit pending, if the dead guy was in the middle of a lawsuit, you're not going to get a lawsuit defense for the $25,000 fee.
Yeah.
Right. So those fees are called extraordinary fees. Those are all applied for on an hourly basis. They're charged on an hourly basis, and they're all subject to court approval. So, and both the attorney and the administrator can ask for them. But what they do is they put together a petition and they say, look, here's the extra work I did. I defended a lawsuit. I did this. I had to sue somebody to collect this money. We incurred $8,000 in fees and costs, or $100,000 in fees and costs. You put it for the court, and the court evaluates whether it's fair and reasonable for the work performed. So that's sense. A place that you can do some negotiation. And even if the client and the attorney agree, remember that you've got to give notice of this to everybody who has an interest, and they can object. And the court, even on its own accord, can look at it and say, I don't think you should get that much. You should get a little bit less. So
you mentioned probate referee. What exactly is a probate referee?
Simplest way to think about a probate referee is that they are an appraiser.
Mm.
So I'll get a lot of people that go, "Oh, Dad died. I have to go get the house appraised." I'll say, "Whoa, hold on. Do we have a probate?" "Oh, yes, we do." Well, if we're going to do a probate, the court requires you to use an appraiser, and not any appraiser. Somebody from their approved panel, and the appraisers on their approved panel are called probate referees.
Oh, okay. So, I didn't realize that. So, yeah. Do they do a full-blown appraisal where they go visit the property and take measurements and stuff, or is it like a drive-by appraisal? Do you know how they do it?
It's more in the characteristic of a drive-by.
Okay. So it's not like a bank where they're going in, measuring, and taking a million photos. And okay. So okay, that's right. And it doesn't if the property sells, does it have to be within 10% of the value of the referee's value, or is there?
It can't be less than 90% of the referee's appraised value.
Okay.
Right.
Okay.
So, but there's some twists on that rule, but yeah, one of the things that we will encounter from time to time is the probate referee will come along and say, "Oh, the property is worth $1 million." And then I'll hire the best in the business. I'll hire Derek, and Derek puts it on the market and does his amazing work and gets all these people who are interested. And they look at it and they go, "Oh man, the best offer I'm going to make you is $700,000." And you come back to me and go, "Scott, I've tried. I've done everything I can. But what the probate referee didn't realize when he drove by is that there's no plumbing in the house, or that the foundation is rocks.
There's no kitchen.
There's no kitchen.
It's a hoarder house.
It's a hoarder house." And so from time to time, what I will often do is I will connect you directly with the probate referee, and I'll say, with all due respect, we respect your opinion, Mr. Probate Referee, but you don't really have a clear picture of what the value is. And it's, I'm not scolding the probate referees. I consider this a dialogue. They're set up to basically do a drive-by appraisal. Sometimes you got to get a little bit more deeply involved with them and work more collaboratively. And I've always had great success. Eventually, we sort through these issues.
Yeah.
So,
Now,
yeah.
another thing I wanted to talk about for PRs is full authority versus limited authority situations. And I guess that is the IAEA stuff, Independent Administrator of Estates Act.
Right. That's
Okay.
exactly.
Can you, first of all, I guess some PRs have full authority to sell a property. Some have limited authority and have to go through the court process and the overbid process. And that ties into the IAEA Act. Can you kind of just expound on all that so our viewers can understand what that all means and how that affects them?
Yeah, the acronym that sounds confusing, the Independent Administration of Estates Act, really the dividing line is whether you have full authority or limited authority, just like you indicated. So what are these two things and why do you do it? Well, it has to do with a couple of things. Maybe the easiest way to explain full authority is if you are given full authority, the court says, congratulations, Miss Administrator, you're in charge. We'll see you in 9 months or in a year or 2 years when your work is concluded, right? And then the administrator comes back and reports, but then, of course, there's a risk that he or she didn't do parts of the job right, or somebody thinks that the house was undersold, or there's all kinds of issues like that. But the key thing is that the court is essentially giving that administrator full authority to go do whatever he or she wants to do. All right? When the award is for limited authority, what the court is saying is, yes, you're in charge, but there are restrictions. The first and most obvious restriction is the one that impacts you, Derek, as being a real estate professional, and that's your ability to sell the house. So the court wants to know that you're, as a personal administrator, going to sell the house, and they want to supervise and make sure that the sale was fair. So what this requires is you do another round of publication on the front end. So you put in the paper you're going to sell the property. You go out and you do your marketing and sale. You accept an offer subject to court confirmation. And then the administrator goes into court and petitions the court, and the court goes through its checklist, right? Did this personal administrator with limited authority publish notice? Yep. Did they hire a realtor? Is the contract okay within the limits of what's allowed? Yep. Is the property properly appraised? Has it been appraised within the last year? Yep. Is it being sold for at least 90% of the appraised value? Yep. And if you're saying no to any of these things, the court will say, we're not going to let you sell it. So you go through all those things, and if all's in order, the court will say, okay, I have an offer here. Would anybody like to overbid? And they have an actual auction in the courtroom that any buyer who qualifies can walk in and actually bid and buy the property on that day. Now, the other piece of it that often accompanies limited IAE authority is when you close the sale, the personal representative is now going to have a pile of money, hopefully, right? So let's say our house is worth $1 million. You sell the house, and by the time you get done, the administrator has $900,000 left after paying all the expenses. What is the administrator going to do with that money? So remember, we sort of skipped through this a little bit, but remember, when the court appointed this person to be in charge, they gave them awesome powers. Remember my story about my wife being able to sign the deed? Right. That's an awesome power. As we sit here today, somebody can't sell my property, right? No notary would allow it. No escrow company would allow it. But the court is handing somebody this awesome power to sell assets. So the question is, do we feel secure that our personal representative isn't going to do something stupid, isn't going to steal, or isn't going to do something bad? And so where you typically find the most common situation for limited authority is that the administrator either doesn't want to post a bond or is not bondable, or out of the sale, the court will force an order the administrator put the funds into a blocked account that can't be transferred without further court order. Now, let me just go back one other point because people may not be familiar with what I'm talking about when I say a bond. So, when you apply to have this awesome job of being a personal representative, administrator, and executor, you're getting this power, and a good will often say, hey, I, Scott, write my will. I trust my wife. I'm going to waive the bond. But if there's no will or the bond isn't waived, then the court's going to look at my wife when she first applies and says, well, what's the value of Scott's estate? And if my wife steps up and says, well, it's $1 million, the court says, I'm going to force you to post a bond. So that doesn't mean that my wife has to come up with $1 million. What that means is she has to go to a bonding company, an insurance company, and say, this court is giving me power to have management and basically unrestricted control of $1 million. They want to know there's somebody to go after if I steal it, right? So will you insure me? Will you issue a bond for my performance? You might, if you're in different fields, you might know this as a completion bond or a surety bond, but that's what the bond is. It's basically a promise from an insurance company that the administrator will not do bad things. And that's really one of your primary reasons why you end up with limited authority, is because either the person's not bondable, or they don't want to pay the bond premium, or there's an issue there. But with limited authority, the short way to describe it is there are more hurdles, there are more challenges, there are more procedural steps that you have to go through. Unlike full authority basically the court says to you, congratulations, you're appointed, good luck, we'll see you in 2 years. With limited authority, they've got their finger on you more closely. That's the best way to summarize it.
And I think if I remember correctly, once they have a price that's acceptable to the court, I believe, does that price have to be published? And is there a published first overbid?
Well, you send out notice of the hearing. You don't have to publish it, but
Okay.
you send out notice and you make it clear at the auction this is the accepted offer. So the petition says, hey, Fred made an offer to buy the house for $1 million. We're ready to close. The first overbid would be 5% plus $500. So the first overbid would have to be this amount of money, right?
Yeah,
So
yeah. Because I mean, normally what we do in the MLS, if the PR doesn't have full authority, is I just publish that first overbid amount in the court, and then publish the court date so other realtors know about it. And I think they got to put down 10% deposit, non-refundable too, right? Correct?
It depends on what your terms of sale are, but that's a general practice, right?
Right.
Yeah.
Got it. Okay. Yeah. Can you explain the distribution to heirs when there's no will? Because I think there are state laws or something that says who gets what. So let's say somebody passes away, and there's a administrator, and they got bonded, and it's an overbid, and then at the end for the distribution, if there's no will, how does the state determine who gets what?
That's a great question, and what this is referred to is the law of intestacy. So I know that sounds like a new version of Ebola or COVID, but it's basically the court's best estimate of who's going to receive your stuff when you're gone, right? And so when we're doing that analysis, one of the first things that we look at is the type of property that you hold. And by that, I don't mean do you owe stocks, bonds, or real estate, but the type of property relative to community property or separate property. Because the first, what I like to say is intestacy essentially follows your heart, right? So if you are married, there's a really good likelihood that you're in love with the person you married and you would want the married person to receive your assets, right? So when it comes to community property, the law of intestacy says if you have community property, your share of the community goes 100% to the surviving spouse. That's where we start.
Well, let's assume for this scenario, it's an unmarried man.
Yep. Yep.
Let's say let's say his wife predeceased him,
Mm-hmm.
and he's the only one left. Got some kids. Parents are deceased. I know that there's a formula. Can you explain that? Because, and maybe I'm wrong to say this to PRs, but I've had PRs tell me, oh, my wife's second cousin, twice removed, whatever, thinks he's getting a share, and he keeps calling me, and he wants to know what's going on and stuff. And I, maybe I'm wrong. I've told him in the past, look, the California laws dictate who gets what, so you don't even have to talk to the guy. Is that correct, or no? Is that not correct?
So there was a lot wrapped up in there. So here's where I'll start. What I'll say is if you love ancestry, if you love family trees, this is family tree land, right?
Mm-hmm.
This is where we map all of this out. But your basic rule is you follow the heart. So if you have a spouse, it's generally going to go there. If you don't have a spouse, the question becomes, do you have kids? Most people who have kids love their kids. So the assets are going to flow down. Now, what happens if you have 3 kids and that's it? Most likely it's going to be divided in 3 equal shares, 1 share for each of the 3 kids. What happens if you had 3 kids but one of them died, but that kid left 2 grandchildren of yours? Well, now we're getting into what's called per stirpes, or as the rules applied in California by default, modern per stirpes, which would say if we use our 3 kids, 1/3 to one kid, 1/3 to another kid, the third to the family of the deceased kid would be split in half again because he has 2 kids. So 1/6 and 1/6 to those people. And then if you can just sort of imagine permeating out, that's how it flows down. So you start with, again, spouse, no spouse, kids, grandkids, nobody below you, then you go up.
Parents?
Right? You go to your parents. Now, most people will say, well, wait a minute. The guy was 80. Of course his parents were dead. Okay, well, slow down. Once you go up to the parents, then the question is, did the parents have any other kids besides the dead guy? In other words, did the dead guy have siblings?
Right.
So you go down again, and then you go down again. So maybe he had 2 brothers who were both dead, but those brothers each left 3 kids. So you might flow it down that way, but you exhaust that tree, and if there's nobody in that branch, you take it up another level to the grandparents, and eventually the great-grandparents, but you go up, and then you go down, and then you go up, and you go down. It's family tree time.
Okay.
So you map it all out. So let's go back to your basic question. You get a call from a random 5th cousin 6 times removed, and do I have to call this guy? So one of the conflicts that we get in this area is, remember, the court has its teeth into the dead guy's assets. The court is going to make a decision and distribute them. The court wants that decision to be final and not be relitigated for the next 40 years. So they're going to make some final decisions. But the essence of them getting jurisdiction is that they give everybody in the world notice. All right? So you end up giving people who are often extraneous notice. That's the first thing. The second thing is there are error companies. There are error finder companies that with every probate, they go down and they search the file and they do a genetic history, and they will literally write to all these strange, distant people and say, hey, contact us. You may get a share of this. One of the more entertaining cases that I handled, probably going back now about 7-8 years ago, is I had what I'll call a fake daughter. So we had a couple that were together. She had a daughter. The couple never married. The fake husband never adopted the daughter. her mother left everything to the guy. The guy treated her as if she were her daughter, but they were not biologically related. Well, at the very last minute, he wrote out this crappy will and he gave everything to her, right? But if the will is no good and it was challenged, it was taken on because one of these air companies found a fifth cousin or a cousin like 3 times removed, then it goes to the testate heirs. And so we were literally, I was representing the fake daughter. We ended up winning this one, but we were being fought by somebody who had not seen the dead person in 54 years.
Dang.
Right?
Crazy.
But the law says, but the law says it goes to biology. That's where it goes. So if you didn't complete this will, then we go spreading through the family tree, and the closest living relative was this lady who had not seen the dead guy in 54 years. So that's why you get all these extraneous people.
And if there is no heirs, because I've seen situations, there are no findable heirs. I guess Gavin Newsom gets everything, the state of California.
You know, he could use the help. More in the budget is always better, right? So that's where you want to leave your money. Just do nothing.
Great.
Have no family and do no estate plan.
Okay, final question before we wrap it up here.
Sure.
How can you, Mr. Scott Schomer, help people avoid this ungodly probate process, and your recommendations to my audience?
Well, so the simple thing is, have you thought or talked about these issues with your loved ones, with yourself? Have you considered any of this stuff, right? Have you thought about these weird questions like what happens if you get hit by a bus? What happens if you have a stroke? What happens if you're not able to manage things, right? Come in and sit down with me and talk with me. So the way that we operate is on a fairly regular basis. We hold webinars and seminars. We hold them in the public. We'll have them in Culver City and various places, Hermosa Beach. And we'll teach you about what all this stuff is. And then out of those seminars, we offer you a free consultation. Come and sit down with us. Now, I will listen to you. I will understand your family situation. I'll understand what your wishes and desires are. I'll make a recommendation to you. For most people, especially if you own real estate in California or elsewhere, you're going to want to create a living trust-based plan, because a living trust is going to keep you far away from probate court with the related documents. It's going to keep you away from conservatorship court. I'm going to solve all these problems for you in advance. But the most important part for me is once you become a client of our firm, we stay very connected to you. So at a minimum, we try to have you back every 3 years. We have clients that come back and see us every 6 months to a year, right? Just to make sure that all the pieces, especially when you have a client that's buying and selling and trading and thinking about different things, come in and sit down with us and we'll review all this. Think of us as your trusted advisor, your trusted quarterback. Just like I have a CPA that I've worked with for 30 years. I connect with my CPA probably 3 to 4 times a year minimum, right? And in fact, I was incredibly sad when he got rid of my favorite receptionist of his. He had this amazing lady that had this great voice, and we sat and mourned. We actually we actually got together and had a drink over the loss of his receptionist. But I have a relationship with him. He knows my taxes. He knows my situation. He knows my plans. He knows my pieces. When I'm debating about how much insurance to buy or where to go or how to do it, he's an integral part of my success. We're an integral part of all of our clients' success. We will guide you. We will help you develop. We will help you grow your wealth. And we will be there to protect your loved ones and your children and anybody else that's important to you. That's what we do.
Great. So basically, you offer seminars at your office, correct? Or other places?
We do them both in our office, on the web, and at local hotels.
Oh, great. Yeah. Got it. Okay. So that's good. And then once they've gone to the seminar, they can just book a private appointment to discuss their situation with you.
Yeah, and if your situation is more urgent, you're always welcome to contact me directly or just reach out to our office, and one of our team will talk to you, and we'll figure out if we can get you in. So
Great. Well, everybody, of course, I will be providing all of Scott's contact information. He's an amazing attorney, handles so many things, really helps people in important life decisions and situations that we're all going to face at some point. If you've been thinking about getting a living trust and you haven't done it, do it. Do not make your family go through probate. It's not fun. It costs money. It's a hassle. And a good, smart, experienced attorney like Scott can help families avoid all that aggravation. So, Scott, thanks again. This was awesome. I learned a lot. I know the audience is going to learn a lot. I'll have all your information published on this video. And thanks again, and we'll talk soon.
Well, Derek, it was a real pleasure. It's an honor to be able to connect with you and work with you. So I look forward to more of the same in the future.
All right.
So
thanks, Scott.
take care.
Bye-bye.
Bye-bye.